Our next case is Kalkaska versus Michigan Municipal League. This is a 15-minute mini oral argument on the application. Ms. Masseron, if you could just give us a minute.
Okay.
Thank you. This is a 15-minute mini oral argument on the application. You both have 2 minutes of a free fire zone, which you may waive. And Ms. Masseron, you may reserve time, but we ask that you do your best to keep track of it yourself. And you may begin whenever you are ready. Take your time, please.
Thank you, Justice Clement, and may it please the court. Mary Masseron on behalf of the Michigan Municipal League Liability and Property Pool. This court granted oral argument on 2 questions, and the first, whether the policy covers claims arising from the 2014 resolution discontinuing a trust and agency fund and the retirees' health insurance, and second, whether the court correctly reversed and remanded for entry of judgment. As to the first, the Court of Appeals said it was obligated to enforce an unreasonable result because of the anomalous nature of the policy. Kalkaska's lawyer told the Court of Appeals at the oral argument there that the village didn't deliberately discontinue its health insurance with the idea that it would have coverage, and called that fanciful, chimerical, and crazy. And yet, the lower courts, charged with interpreting the policy in the way the common person would understand its meaning in the context, have adopted that anomalous, chimerical, crazy reading of the policy. That can't be right. That both sides see the outcome as crazy signals a mistake, a drastic mistake in interpreting the policy language. As to the second question, the Court of Appeals wrongly granted judgment for Kalkaska despite its not having asked for that relief in the trial court or the Court of Appeals, neither party having briefed it, and despite the pool having explicitly reserved all other issues, including damages, in the relief clause of its motion for partial summary disposition. Tom Wolf's affidavit shows that Kalkaska seeks coverage for multiple claims that were never timely reported to the pool, and the pool was not given notice or the opportunity to be involved in the litigation or settlement. You can find his affidavit in the appendix at 306A and 307A. The parties never addressed damages and other related issues in the briefing or argument. So the Court of Appeals' precipitous ruling deprived the pool of these policy defenses and arguments about damages that raises serious due process concerns about imposing a judgment at this juncture. I'm happy to answer questions at this point. The language in the policy does not give rise to coverage. The endorsement does not grant coverage as an initial matter when an insured contractually agrees to provide a retiree health benefit program and then deliberately adopts a resolution discontinuing it. The endorsement covers liability for any wrongful act in the administration of the insured employee benefit programs.
So, Counselor, the contract defines administration as affecting enrollment, termination, or cancellation of employees. And so I think that opposing counsel would say this is the termination of employees from this plan. And were there other employees of the village still within the plan? Help us understand a little bit more what our record shows on the facts there, and then why what happened here isn't covered under that language.
Right. There's an emphasis here to try to focus on Blue Cross Blue Shield, and oh, there's all Delta Dental, there's still people in these plans, and somehow that changes the outcome.
Are there still people in these plans?
In the retiree health insurance
Yes.
plan that was created in the letter of understanding and that was discontinued by the resolution, the answer to that is no. Are there people employed by the village who are not in the retiree health program but have other programs that are continuing to get Blue Cross or Delta Dental? I think the answer to that is yes. So what you have to look at, though, is what is the plan? I tried to put this in a brief a little bit. It's a highly technical, confusing area, employee benefits. But under ERISA, if you have a health benefit plan, you have to lay out who will be the participants, what's the nature of the benefits, how are you going to fund it. ERISA did that because it wanted to make sure people didn't do what Kalkaska did here, which is promise lots of benefits and not have any plan of how it would pay for them. Once ERISA was enacted, insurers began creating these employee liability endorsements. Why is that? Because the ERISA statute is highly complex, and now there were all sorts of administration issues and issues about the fund and other issues that are governed by that statute and generally. And therefore, these kinds of endorsements came into being. In this case, what the language talks about, and I think this is clear from the language, I think it's clear from the context, and I think it's clear from a technical understanding of ERISA, talks about administration under a program. And the acts that it lists are acts directed toward employees under a program. That's not what Kalkaska's council did. What Kalkaska's council did was enacted a resolution over the program as a whole, discontinuing it. That's just not what this policy was intended to cover, or what the words...
That's material because it relates to the language of the policy.
I'm sorry, I didn't hear you.
That's material, the fact that they ended the plan as opposed to terminating the participants of the plan because of the language of the policy.
That's exactly right. That's exactly right. And somehow the lower courts lost that point in the confusion, which is understandable, but we're looking to this court to correct the situation on that.
The underlying judgments against plaintiffs represented an equal amount of damages for the years 2016 through 2027. If the judgments actually exceed plaintiffs' pre-existing obligations to fund the program, who would be on the hook?
If the judgments exceed the pre-existing program, then it seems to me that if there was coverage, the pool would be on the hook. Our position is there's no coverage because there's no act of administration. But if you get to the damages and you assume there's coverage, then I think that's a critical point, which is another reason why we've tried to argue if you owe pre-existing coverage, and Brother Counsel has tried to say there's no cases supporting our position. That's just not true. The YMCA case and any number of other cases make a distinction between an obligation that is owed by a pre-existing contract. That's not a loss that occurs under a policy for which coverage is provided. That's true in the language, the insuring language, and it's true in the whole context of insurance.
But couldn't that apply to anything? You have a contract with an employee and you, let's just assume they're not at will and you've promised them 2 years of employment and something. I mean, isn't that a pre-existing obligation?
What, excuse me, what in the YMCA case, May department stores case, there's a number of cases that lay this out. What they say is, if I have a contract with John Smith and I agree I'm going to pay for his health insurance, and then because I don't like him, terminate him from that coverage, and he has appendicitis, rushes to the hospital, has surgery, and gets stuck with a bill, he can sue if there's coverage under the policy. And here, I've deliberately terminated him because I don't like him. So that's probably a violation. It's an act with respect to him. It's under the policy. He's supposed to get it under the policy. What I would be on the hook for in terms of damages is not what I already owed, which is the cost of maintaining his health insurance, but the $40,000 hospital bill, or whatever it would come to in this day and age. I would be, as the insurer, on the hook for that, because that is something that the entity that purchased this policy is now on the hook for because of the breach of contract, and it's not something they already owed. And that is what the May Department case and the YMCA case and a number of cases in the pension context and in profit sharing context have said that is the proper way to approach the question of damages. And it makes sense.
So if we thought there was a breach, you're saying that then those retirees who were supposed to benefit and were cut off, the damages would be their hospital bills or their medical bills?
Something beyond, yeah, if they have, if there were,
As opposed to funding the plan?
if there's coverage, which we don't believe there is, but if the court disagrees and says there's coverage, then we get to the question of what damages can you collect. And under a whole ream of cases cited in our brief, and I would actually encourage you to dive deep into the list of cases in Brother Counsel's brief. I think it's at pages 26 and 27, because I read those cases again yesterday, and I don't believe those hypotheticals accurately convey the full discussion about this issue. What the courts have said is, where you already owed. So in the pension, for example, that one of the cases talks about a pension example. Pension payments were to be made from both the employee and the employer. So no payments were made, a claim was made against the insurance. In that circumstance, the insurance was covering it, but what the court said was, the part that you were already obligated for, that is, you were supposed to pay as the employer, you don't get to collect from us. That's your obligation. You took that on before.
So, Counselor, I think that Brother Counsel made this point in his brief, and so I'd like you to respond. Looking at the text of this particular provision, he suggests that there are other places in the contract that exclude breach of contract. And so we should infer that while maybe not in the normal course of things, a breach of contract would be covered, that it is covered under the language of this particular contract. So maybe you could respond to that.
We have not disputed that in the Court of Appeals or in this court, that there was an argument about an exclusion from coverage D in the trial court. It was waived, and Brother Counsel keeps raising it, spending lots of time creating a sort of razzle-matazzle of confusion, which is whatever. But that is not our position, and that's why I used a hypothetical in which an employee deliberately fired somebody because they didn't like them. That would be a breach of contract, the employment contract. And it would also be covered to the extent there were damages beyond what the employer was already obligated to pay. I've only got a minute and 20 seconds for rebuttal, so perhaps I should
Save it, yes.
reserve that. Thank you.
Good morning, may it please the court. John Moodhart for Village of Kalkaska. A brief comment about the crazy, chimerical, insane. I don't believe that we ever took the position that the idea that this would be a covered loss was crazy. The position that I took in the Court of Appeals, and I would reiterate here, is that it is crazy to think that the village did this purposefully with the idea that they would incur millions of dollars of liability to their employees and then just send the bill to their insurer. This was done on the basis that they believed, and this is all set forth in the Court of Appeals decision in the Thomas v. Village of Kalkaska case, which was an appeal of one of these things that we ended up being liable for. The village believed that they had a 3-year limit on this obligation. The trial court ruled that there was a patent ambiguity, denied summary disposition, and conducted a jury trial. And so this is not a situation where the village simply just said, well, we're just going to terminate all these people and let the insurance company pay for it. That's just not factual.
If this is affirmed, isn't that what every other Michigan Municipal League insured with a similar program going to do?
Well, I addressed that in the brief, Justice Zara, and I did mention that this happened 10 years ago, and I'm not aware of anybody else doing this, and I'm sure by this time that to the extent that they're concerned about the language of their policy, they probably changed it by now.
So what did this policy need to say? Because I, from a policy standpoint, this is an amazing outcome. Like, we've got these legacy insurance costs all over the state for every municipality in the state. This is a huge discussion going on everywhere. It does seem odd that you can just put it on your insurance company. So,
Well,
what did they need to do here?
Justice Welch, what I will say is this, is that I think that the sister council and I agree on one thing, and that is, and this is from their brief, if the village did not cover an employee that should have been covered under the plan, or dropped an employee from coverage under the plan, when that employee should not have been dropped, Kalkaska is covered. That's what they say in their brief. Those are their words. And that is what happened here. We were sued by employees. The suits say, and this is in the appendix, that the wrongful, unlawful act of the village was, quote, that it sent a letter to the employee that the employee's health benefits would be terminated. And this is not a situation where there was some sort of wholesale cancellation of an entire employee benefit program. There were 6 people, 6 employees, whose health care coverage was terminated. There's an individual termination sheet for every one of them, again in the appendix. This is all referenced in the brief.
But isn't the program, in fact, just those employees?
It is
I mean,
not.
the letter of understanding,
It is,
which is what created this retiree program, right, and entitled the employees, these particular employees, it exists by virtue of the letter of understanding, correct? There may be other programs, and the policy defines them as employee benefit programs,
Yes.
meaning that you could have multiple,
Yes.
right? This program that we're talking about is created by a letter of understanding, and then by virtue of the resolution is specifically referencing that letter of understanding. Why is that not eliminating the program?
the reason that it's not eliminating the program is that there are 2 terms in the policy that MML is attempting to redefine. One of them is bringing ERISA into the idea of what constitutes a program. I mean, this was never argued below. There's no federal law implications here. The policy itself defines what employee benefit programs are. It says employee benefit programs means group life health insurance, group health insurance, disability benefits insurance, group dental and or vision plans, pension plans, social security benefits, and unemployment insurance. All of these plans, all of these programs are run by third parties. They are not little mini letters or contracts between the village and its 6 employees.
I just want to take a step back. With the exception of Social Security and whatever the last benefit you identified, is there any question that all those things are covered by ERISA? I mean, for 30-plus years.
Certainly not,
All
but-
employee benefit plans, it's an established fact, they're covered by ERISA.
Of course, Justice Zara, but we don't go to ERISA to determine what is an employee benefit program under the policy. We go to the policy definition where it says employee benefit programs means, and then we read what it says. This is a contract case.
The MML policy.
Yes, yeah, and
But
it
don't we
says it
first have to
means,
establish whether it's a program, whether it's whether it's a constituted employee benefit program under established state and federal law?
I don't think the policy has anything to do with what's an established federal, state, and program under federal law, under state and federal law. There's a definition in the policy that tells us what it means.
Okay, so
We've gotten to the point.
Let's say that we agree with you. What I'm still struggling with, regardless of how we define program and whether this is in existence and others still are, or what have you, what I'm struggling with is how a decision to end the program is conduct that affects, with an E, right, bringing about termination under a program. How do you act under a program that doesn't exist because you've
The program is
terminated it?
Blue Cross Blue Shield, Justice Kavanaugh.
Well, but
And 6 employees were terminated under the Blue Cross Blue Shield program.
I
can
thought you
see-
said, so you
can-
don't think the program is created by the letter of understanding?
The letter of understanding is not group life, group health insurance. It is simply an agreement to provide that with employees. It is not in and of itself group health insurance. Group health insurance is what Blue Cross provides. We've gotten to the point here where the reply brief actually says that Blue Cross is not group health insurance. I mean, I don't get that.
Well, but those individuals wouldn't be entitled to group health insurance without the letter of understanding,
Well,
correct?
none of our employees would be entitled to group health insurance if it weren't a benefit of their employment. I mean, there's nothing that requires us to provide it.
No, but-
It's a benefit of employment to provide
Well, but
group.
these are retirees that you agreed by a letter of understanding to provide this benefit.
And we agreed with all of our other employees to provide that benefit pursuant to their contracts. Doesn't make the contract itself a group health plan. The group health plan is the one we bought from Blue Cross and then provided as a benefit to all of our employees. The letter of understanding isn't a group health insurance plan.
Counsel, what do you make of Sister Counsel's argument about the damages? If we were to agree with your position that there was a breach, is it the full pre-funded amount, or is it sort of case-by-case basis based on how people are impacted?
Honestly, today's the first day this has come up that I can recall. I mean, it wasn't raised in the lower courts, and it wasn't raised in any of the briefing that I can recall. Damages, I believe, in terms of what are the policy limits and what are the damages, are still at issue in the lower court. And I don't
So
think
that
they're
would
at
be,
issue.
that would be hashed out later.
I do not believe they're at issue here at all. I mean, I don't think that this court has got a sufficient record, and indeed there's no record about damages at all with which to work in order to say, well, these types of things would be covered and these types of things wouldn't be.
In the underlying Thomas case, didn't you move for remittitor?
Yes.
Well, what is that telling me?
I don't understand the question, Justice Zara.
Does that not mean that you believe that you were held liable for amount over and above the pre-existing obligation?
I think to tell you the truth, I wasn't on that case, and the record that I have reviewed doesn't tell me the answer to that question.
Well, I
Wasn't an
certainly
issue
felt that it was
below.
raised in this case, and that's why I asked the question of your sister counsel, and the whole motion for remittitor seemed to feed into this whole notion for me, so it's not new to me.
Well, I guess we would have to know what the motion for remittitor said and what was argued and how it came out. And I don't believe that the record in the Court of Appeals will answer that question. I mean, it could very well have been a motion for remittitor that was filed by defense counsel at the time, just to say, I know that part of it, for sure, when I read the brief, is that there was an argument in the Court of Appeals that there was not an appropriate discount to present value of the future damages in the trial court in the jury's verdict. My understanding, Justice, is that is what the motion for remitter was, and I think if we review the Court of Appeals Thomas case, that we'll find that's what it says. I believe that's what the remitter motion was about. It was simply a matter of you should have reduced future damages to present value, and you didn't do that.
Can you tell me, so going from the discussion, jumping back a little bit, where you said that the plan is not the letter of understanding, it's the Blue Cross Blue Shield Group Health Insurance program. If Kalkaska said, by resolution or otherwise, we're not doing it. We're canceling our group health insurance. Is that administration affecting enrollment, termination, or cancellation of employees under the program?
That is an excellent question. And there's only one case that's been cited in this entire appeal that addresses that issue. And it was cited by MML, footnote 10 of its brief, and it goes back all the way to the trial court. It was cited back there the first time, and that is the Stinker Stores case out of the Idaho Federal Court. And there's been some scorning of the Idaho Federal unpublished. This is dealt with in the briefs of MML as the sort of, and I'm paraphrasing, the unpublished musings of a federal judge in Idaho. I did a little research on this judge. He did get a start as a state Supreme Court justice, so that's a pretty good pedigree, I would think. What that case says is, a decision to terminate an employee benefit plan may qualify as an act which causes the termination or cancellation of an employee under an employee benefit plan. We vehemently disagree that the termination of 6 of our employees' coverage, one at a time, form by form, as you can see in the appendix, is pulling the plug on an entire employee benefit program, because the definition in the policy doesn't line up with that. But the only case that's been cited to you on that issue says that if that were the case, it would still be an act which causes the termination or cancellation of an employee under an employee benefit plan. The redefinition issue as well is just to mention this. There's been an attempt to redefine the policy definition of employee benefit programs by use of ERISA definitions. That is, I think, inappropriate, because policy is a contract and it says what it means. It uses the word means, and it says the same thing under administration. Administration means affecting enrollment, termination, or cancellation of employees under the employee benefit programs. That's what Kalkaska did. 6 times, 6 forms, 6 employees out of all of their employees. And
Counsel,
so,
can a municipality just stop paying their bills and then look to insurance for the wrongful act? Like the electric bill?
well, it depends, I guess, on what the policy says. I mean, there's this sort of overarching, this is not insurance, this doesn't seem quite right, this doesn't seem like this would be what insurance should cover. The problem with that argument is that the precedents of this court and the Court of Appeals are very clear that insurance contracts are contracts just like every other contract. And there are a lot of times when the insureds want to make a different pitch, and they say, well, that isn't really what I expected. I think they should cover this. And the courts of our state have been very, very harsh with insureds when they try to do that. But when the insurance company has a policy that they don't like, which covers, by the way, malfeasance, every other case that's cited in all of the briefs deals with and requires that the act be a negligent act of the insured. If they did it on purpose, it's not covered. Here, the policy language is very clear and it's very different, and it says malfeasance is covered. And we cited the Hazel Park case, which cites the Black's Law Dictionary of malfeasance, which expressly includes contracting for that which, not doing that which they contracted to do. That's one of the definitions in Black's, as cited by the Court of Appeals in Hazel Park, as malfeasance.
Can I get to just the second question? Assuming, say we agree with, even if we were to, if we agree with you on the coverage analysis, why was the Court of Appeals granting summary in your favor, not premature?
Well, we cited the court rule, MCR 7.216A7, that allows that, case law that in which the Court of Appeals does that. And I mean, again, noting that damages are still at issue in the lower court. This is simply a liability determination that there's coverage. And so,
But there were asserted exclusions, correct? I mean, coverage is only the first step of the analysis.
I don't believe any of the exclusions, I mean, the exclusions were such that the exclusions, no, I don't believe so, Justice Kavanaugh. I believe that the exclusion that was asserted was that there's a breach of contract exclusion. It's under coverage D, which doesn't apply here. And that was, I believe, sister counsel indicated, something that has been waived. I'm not aware of any other exclusion that would be asserted here. I mean, the MML's entire position here is that there's a lack of coverage in the initial, there's no grant of coverage initially, is I believe what their argument is.
It's an interesting quandary. Because obviously this is an insurance pool that is put together basically, by municipalities for municipalities. So I would imagine the goal was to provide broad coverage, but you're basically telling me they could not pay the electric bill and somebody could look to their insurance company.
Well, I didn't say that.
No, but I mean,
Justice.
you're saying it doesn't, it's not excluded and it's not.
What I'm saying here is that we need to, I believe this court is bound by the definitions in the policy. And it's bound by the language of the policy. We all are. We're all stuck with it, all of us. And none of us have the right to say, well, when it says administration means, and it gives a definition, to say, well, that's not what administration means. We're going to go look at the Google English Oxford Dictionary.
Yeah, I agree that there's not
That is not
intentional exclusion. Like I know that other policies would specifically say, what needs to be modified, and I suspect probably will be modified moving forward, no matter the outcome.
It is an unusual provision to say that we're going to cover you for intentional acts, malfeasance, but it's there. And that's the deal we made. And that's the deal that my client, the village, is entitled to. The one that's in the contract written by the insurance company that they paid tens of thousands of dollars through the years for this coverage.
Thank you.
Thank you.
You have 1 minute and 15 seconds.
I'll try to talk fast. First, council said repeatedly, under the plan, under the policy, under the program, and that is a question of interpreting the language in the policy as it's written in a way that makes sense of the policy as everybody would understand it and as the plain language understands it. It also is a rule of this court to look at language in context. And as Justice Zara's questions went to, and as we've argued in our brief, not just in this court, but throughout this case, the policy needs to be understood, and the plan, the benefit plan, needs to be understood in the context of ERISA. And that confirms the idea that we're looking at the letter of understanding and the resolution. And when you look at those two things, it seems to me a reversal is required.
Can you tell me why you believe that summary, at a minimum, summary was granted prematurely to the village?
Unquestionably, the motion was for partial summary disposition. Even discussing this damages question, which has been raised throughout, Brother Counsel said, well, that could be sorted out on remand. That's a pretty clear sign that at a minimum, a remand for further proceedings would be in order. Also, the court rule empowers the court when different relief is appropriate because the parties have briefed it, everybody's had their day in court, the record is clear to do something. It doesn't empower a court to arbitrarily cut off proceedings when there was a motion for partial summary with a relief clause that explicitly reserved various additional arguments, including damages, right in the relief clause. And then when the Court of Appeals dealt with this, that relief was never sought, it wasn't discussed. You can look at the oral argument video online, see the fancy chimerical comments of Brother Counsel, but also see that There was no discussion about, okay, now we better end the case because everything is completed. Happy to answer more questions. I really appreciate the court's time.
I don't see any other questions. Thank you. Thank you both. The case will be submitted.